is Elena Porter, and I am a member of the Afro-Descendant Institute for Human Rights, and also I am one of the first signatories of the Afro-Descendant Confederated Nation. Holding on to the Jamestown 1619 myth as the first blacks in America prevents U.S. Afro-descendants from joining Native Americans as having a pre-existing status. Their early presence serves as the basis for moral and legal rights for Native Americans, such as the case under the International Legal Doctrine of Historic Title. U.S. Afro-descendants' existence did not start with enslavement in the Americas. Overwhelming evidence proves Africans frequently sailed across the Atlantic to the Americas thousands of years before Columbus. Walter Nevis presented the results of craniometric analysis of a set of ancient human skulls originating from diverse regions of the Americas in 1989 at a scientific event in the U.S. Walter Nevis proposed that a group of humans with Negro features distinct from Mongoloid features occupied the American continent during a much earlier period than supposed. The Afro-Descendant Institute of Human Rights analyzed the historical development and current situation of Afro-descendants in the U.S. using the international human rights and internal colonialism framework. Afro-descendants constitute the most marginalized economic and social group in the wider U.S. Why and how is this possible? In 1776, with the attainment of nationhood, the United States colonial history ended for Euro-Americans, but not for U.S. Afro-descendants. U.S. Afro-descendants live in a perpetual state of apartheid. Sister Cecile showed us that. Colonization, crimes against humanity, and genocide. Apartheid, colonialism, crimes against humanity, and genocide remain a political reality, one which now existed for more than 500 years. This presentation seeks to explain policies and practices over this span and argue that theories of international human rights law and internal colonialism provide an important framework for the realization of restorative justice. Injustices U.S. Afro-descendants experience fall under the jurisdiction of international law. Reparations must be assessed within a broader framework of colonialism. The benchmark for assessing current and historical acts of crimes against humanity in a global context is the year 1955, the year of the Bandung Conference. The Bandung Conference gave the Third World its first infusion of global self-consciousness. Virtually all sub-Saharan Africa was under colonial rule in 1955. The United Nations recognized Sudan, Morocco, and Tunisia as independent states in 1956, Ghana in 1957, and Guinea in 1958. However, colonial rule began to diminish when 16 African states became independent in 1960. This is an important framework to invoke in explaining reparations for U.S. Afro-descendants. If we truly want to understand the social problems U.S. Afro-descendants suffer, we must consider the dynamics of colonialism in 1955. Why is the colonial analysis important? A summary of the dynamics of colonial relations exists that allows us to draw our own conclusions. Afro-descendants' current reality indicate that the U.S. government has become a colonial power because it practices policies associated with colonialism, such as it attempts to annex the territory that it is occupying and administer it in a way that denies Afro-descendants the right to self-determination. It assumes permanent sovereignty over natural resources, and it transfers its own population into the territory it occupies with an apparent intent to colonize it, or systematically and knowingly provides protective conditions for mass civilian settlement that effectively deny U.S. Afro-descendants their right to self-determination. Since the U.S. continues to do these things, it has become unlawful on the grounds of colonialism. U.S. Afro-descendant status do not disrupt the U.S. government's territorial integrity. The reason why they are not violating the U.S. government's territorial integrity is because international law gives colonial people a status separate and distinct from the U.S. government. The principle of territorial integrity prohibits succession, but not decolonization. Afro-descendants must ask the United Nations to admonish the United States to take immediate steps to transfer all powers unconditionally to them and pay reparations. States are supposed to protect minorities. People have a right to self-determination. This is significant. According to the Convention on the Elimination of All Forms of Racial Discrimination, minority groups identified by race, color, descent, or national or ethnic origin may not be subjected to any distinction, exclusion, restriction, or preference, which has the purpose of or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in any dimension of public life. Although this is an important principle, standing alone, it does not redistribute wealth, power, and resources. The ICER Treaty simply prohibits those exercising that power in public from discriminating between people based on identity. Self-determination provides an entirely distinct body of rights. Common Article 1 of the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Self-determination involves the right of all people to dispose of their natural wealth and resources based on the principle of mutual benefit. International human rights law supports this. The U.S. government cannot deprive U.S. Afro-descendants of its own means of subsistence. The 1970 Declaration on the Principles of International Law concerning friendly relations and cooperation among states states the establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence of any political status freely determined by a people constitute modes of implementing the right to self-determination of U.S. Afro-descendants. Self-determination manifests in many forms, but they involve empowerment instead of equal treatment at the hands of the offender, the U.S. government. The right to self-determination remains authoritative as internal just cougars, a norm from which no derogation is permitted. UN officials no longer limit self-determination to freedom from overseas colonialism and foreign occupation. Self-determination extends to us, U.S. Afro-descendants, as well. If U.S. Afro-descendants pursue the path to self-determination, restorative justice, and internal decolonization, they have critical tools at their disposal. The Afro-Descendant Institute for Human Rights established that U.S. Afro-descendants have a variety of rights under international human rights law, including the right to self-determination. We cannot continue asking Congress and the Supreme Court for reparations. Reparative remedies for enslavement and post-slavery war of attrition requires a self-determined process. The Santiago Declaration, authored by the Organization of American States, makes U.S. Afro-descendants subjects of international law. Thank you.